Good afternoon and welcome to today's webinar, COVID-19 Real-Time Legal Response, focused on quarantine, isolation, and other social distancing powers, brought to you by the Network for Public Health Law. I'm Charles Strong, the Digital Marketing Coordinator at the Network's National Office, and I'll be your host for today's webinar. A quick note that both the presentation slides and video playback for this webinar will be available on our website shortly after the conclusion of today's event. We strongly encourage attendee participation and would love to hear from you, so feel free to submit your questions at any time during this webinar by using the Q&A tab on the right-hand side of your screen. All you need to do is click on that tab, select all panelists from the drop-down menu, and send us your question. We will address them during the Q&A session at the end of today's event. Your moderator for today's webinar is Kayleen Claridge. Kayleen is the Marketing and Membership Manager here at the Network's National Office, where she assists in the development and execution of our national marketing and communication strategy, as well as the Network's membership program. Prior to joining the Network, Kayleen worked for a nonprofit association management firm where she assisted nonprofit scientific associations with the marketing of their memberships, annual meetings, programs, and services. Kayleen will be leading us through the rest of today's webinar, so Kayleen, over to you.
Thank you, Charles. At this time, I'd like to introduce today's presenter, James G. Hodge, Jr., the Director of the Network's Western Region. He is the Peter Kiewit Foundation Professor of Public Health Law and Ethics and Director of the Center for Public Health Law and Policy at the Sandra Day O'Connor College of Law at Arizona State University. Through scholarship, teaching, and projects, Professor Hodge delves into multiple areas of health law, public health law, global health law, ethics, and human rights. His current work focuses on emergency legal preparedness and response, vaccinations, preemption, emerging infectious diseases, and constitutional rights and structural principles. Now, I'll turn it over to you, James.
Kayleen, thank you so much, and welcome to everyone who's able to join us here today in regards to the webinar. What an extraordinary moment in our nation's history. From a public health perspective, it does not get any more intense than what we're seeing right now. So to be sure, we are going to do our very best to kind of unravel a little bit of what's transpired over the last week alone in regards to social distancing powers and all of the key interventions and legal observations that we can possibly make. Now, the pace will be torrid, as you've seen and perhaps been on board with me for some of our network webinars, for the reason that we want to get through some good early observations, do our very best to take on every question you've got, and my promise to you is if we don't answer your question here today, you let us know through the network or through a direct email to me, and we'll be back in touch with you to the fullest degree we possibly can. We are literally triaging, as you'll see here momentarily, as I'm sure you all are, in regards to frontline public health practice work happening across the country. So let's set a couple ground rules like we did with our last webinar, and we're going to make these quick and easy. First of all, hey, some of the information I've got for you on these slides is right up to the minute. We just finalized them this morning. They may already change before our eyes. It's moving that fast. So should there be specific updates that occurred during the course even of this webinar, my apologies if we don't have the fullest information about perhaps what the White House is doing, but otherwise, we're going to take what we know and it's going to be state-of-the-art for what we've got coming into it. Second, let's put the politics aside, as we did with our last webinar. There are so many political overtones here that absorbing them and trying to actually assess the proper role of law and policy in regards to this environment, it's tough. So let's just put them aside. But let's also be conscientious of what we saw over the course of the weekend. Now listen, one of the nation's top public health experts, Dr. Tony Fauci at NIH, made it quite clear again on national television, on multiple television programs, everything's on the table, according to the White House. So what does that mean? That means the role of law and policy in regards to how we assure that from a social distancing perspective, as we explore what's optional or what's possible with COVID, that we do the very best to actually set the parameters for how we can think through what is actually possible and quite honestly, what may not be. Now, without further ado, let's go work through these primary objectives and do so in rapid fashion. The Epi Snapshot is virtually what you've seen in regards to COVID, but some of the more alarming information you'll see on screen here in just a minute about just how fast this is spreading nationally. We'll talk about emergency declarations. We'll give you a sort of sense of where we stand, the president's emergency declarations on Friday, other key fronts. We'll just lay those out for you very briefly. That's a backdrop to all the emerging legal and policy issues we know you're dealing with nationally. We are here, however, to focus on probably the most controversial of those, the social distancing measures. What and how, from a public health perspective, are we using tools like closures, assembly limitations, travel restrictions, quarantine isolation, other initiatives you'll hear about, what's possible, what's legally viable? We'll be exploring all of that. And as I say, the Q&A session here will be really rapid. We're going to work through just as many questions as we possibly can. All right, without further ado, your Epi Snapshot is exactly what you already know. This thing's serious. It's a killer. It spreads quickly. It's like flu. You may be spreading it asymptomatically. Most importantly, there's no vaccine, there's no proven treatment. The only difference of what you've seen me talk about perhaps in the last week or so is as follows. Tests are becoming increasingly more available. That's going to change our profile and assessment of just how serious or non-serious of a threat this is. But to be sure, everything else is still on the table in regards to how significant of a threat this is to the public's health. This slide is just revealing the New York Times is doing a great job of showing us where different cases are across the United States. Big circles are hot spots, as you know, in Washington State, Seattle, various parts of Northern California, LA. You're seeing New York City now with hundreds of confirmed cases. It's just amazing in a matter of literally 2 weeks to see us go to 3,600 confirmed cases, several more probably now, obviously, 61 total deaths. How long will it be before we have to put a zero at the end of that 3,600 number? And I sure hope we don't have to put the zero at the end of the deaths. But to be sure, we've got very significant trajectories ahead. Why? Because even according to initial CDC modeling, as we've seen reported by the New York Times, between 160 and 214 million people in the U.S. could actually be infected over the course of this epidemic. And that could last months. We could have multiple stages of this, multiple waves, as we often talk about from an epi perspective. The numbers of potential deaths, the mortality figures are alarming, 200,000 to 1.7 million. That was the best projected estimate by CDC a month ago. How are we going to work hard to make sure these numbers do not materialize? We're going to use law fully and effectively to do everything possible from a social distancing perspective to drive down that curve, or as Dr. Fauci talks about, to kind of tamp that wave or really sort of narrow down that bump. So what do we have available to us? Literally every level of emergency you're seeing on screen right now is in place in the United States and globally. And so what and why is this so critical for us? Because as I've mentioned before, gosh, when you get into this emergency status at every level of government, it flat out changes what you can do. It alters the legal landscape, and it gives you options you might not have had before from a public health perspective. Options that are still legally sound, but don't look and feel like how we've actually operated in the past. Literally every emergency you're seeing on screen here is available and been declared in the United States as we speak. For example, WHO, as you know, issued a public health emergency of international concern, over 6 weeks ago. And the red day right after that, HHS Secretary Alex Azar declares a national public health emergency. Now, that's a good first effort, obviously. It made some differences for sort of a raising awareness among states and getting some specific information and medical countermeasures at play, including emergency use authorization through FDA and a lot of focus by CDC. It had its purpose and point in time, but to be sure, by March 13th, on Friday, you saw President Trump in the Rose Garden declare 2 simultaneous emergency statuses. That's not typical at all, as you know. In fact, I'm not aware of any single moment where the president simultaneously declared 2 emergencies consistent with the National Emergencies Act and the Stafford Act. But he did on Friday, and in doing so, he invoked the full gamut of what the federal government has available to facilitate and respond in real time along with the states. We're talking about access to that mega fund the Disaster Relief Fund, FEMA has already in its possession, of which reimbursement and other emergency protective measures can be fully paid for, at least until the fund runs out. We've got potential for waivers through Section 1135 provisions of the Social Security Act that will come into play already, affecting things like select Medicare, Medicaid rules, S-CHIP, the HIPAA privacy rule. Watch out for EMTALA-related changes to start to arise soon. We've got the additional sort of a federal assistance to states and localities directly flowing from these emergency declarations. That's powerful, and you'll see just a little bit more here in a moment what that and how that might play out. Every agency on screen, I've said before, has a role to play, but now, more importantly, pursuant to the National Emergency Act, every agency you're seeing on screen and others that are off screen too can now sort of basically mobilize around the emergency authorizations they have that get tripped and invoked by the National Emergency Act. So these enterprises can do specific things now, like FEMA, Department of Homeland Security, they couldn't do before because of that National Emergency Act issue. We're going to see and watch this start to play out over the next week ahead, to be sure, and some of those observations will be regularly featured in our COVID Legal Primer, which is a separate document, as you know, on our network website. What you're seeing on screen, on slide 15, we have never seen before in the United States, period, ever. This is unprecedented. All 50 states having declared some state-based emergency. And I mean literally hundreds of localities and tribal governments, which we can't possibly list, but we've highlighted many of them here, have also declared local states of emergency. Why is this so profound? Well, first of all, look at the diversity of colors on your screen. These are public health emergencies in yellow, these are disaster declarations in purple, and these are emergency declarations in blue. These mean different things. And by the way, the orange, like Florida, Maryland, these are states that have actually declared both an emergency and a public health emergency, just like President Trump basically has done on Friday. Now, with this in mind, these invoke different powers depending on the type of emergency declared. We're not going to get into all the details of what that means, but I can just assure you these are differences that have some profound implications across the states. What are we doing? What are we up to right now? I think probably if you're involved in public health on the front lines, you're triaging. You're triaging public health needs. You're going to be triaging patients real soon, if not already. I guarantee Seattle and New York and other places are already seeing that occur. You're going to be triaging the legal issues. This is what we're actually up to right now in the network. We are doing our very best to actually assess fully what those legal obstacles or inhibitions are to an effective response, and then we're prioritizing those issues, finding solutions to the fullest degree possible so that we can facilitate those legitimate public health responses. You know, we talk about legal triage in this regard, and we're actually doing it in real time. It makes a huge difference. It can be the reason for authorizing or not specific activities. Just be conscientious of what goes into it, and if you're working through the toughest legal issues and need guidance to that effect, without it being legal advice, as you know, let us know. These are the types of issues I think we're all seeing across the country. We're talking about emergency powers and triage, of course, crisis standards of care, good heavens, that's going to arise. The sensational issues that we've already seen in multiple localities are about to play out across the country in so many different ways, unless, again, we can tamp down incidents of infection. Liability, insurance, privacy-related concerns, surveillance concerns across the board, the reporting mechanisms, who we're going to test, under what circumstances, how are we screening, what treatments are going to be available, and who's first in line for those. Wow, these issues are going to be some of the toughest, difficult issues ahead for a lot of localities and states across the country. But today, we focus on, I think, the most controversial of those, social distancing. These are the types of interventions that often I have to explain in non-emergencies are available. We use them, in non-emergencies, and we can use them in emergencies when needed. I say that from the perspective that when we're not in an emergency, these look fairly benign, and we'll use them where we need to. But now you are using them. Now you are putting these into place, I know. And now what you're starting to see is what and how the public reacts to that. Issues related to how you might control modes of transportation, increasing distance among workers within specific settings, how we might have to dismiss schools, which is happening in so many jurisdictions right now, how we restrict public gatherings, the isolation and quarantine issues that are profound, even issues of evacuation of specific premises that may be necessary. We have multiple localities instituting curfews. And then perhaps the most controversial that we'll get to, the cordon sanitaire lockdown scenario that you keep hearing about the media focused on from China, Italy, France, and other places. Is it possible in the United States? No, we'll get there. We'll look at that from a constitutional perspective. Now, with this in mind, what you have to work through consistently is to recognize no matter what emergency authorities allow us to waive from a regulatory or statutory purpose for the duration of the emergency, there is nothing about waiving constitutional norms during these periods of time. What gets rebalanced, however, is how individual interests, say to rights to assemble or equal protection, issues related to due process from substantive or procedural perspective, or even religious freedoms, how do these get balanced differently when we're trying to do literally everything we can to control for a menace like what you're seeing with COVID? That's what's getting rebalanced, and it's going to play out in some very curious ways. So this brief chart is just giving you a foreshadowing of what we're about to discuss. What's constitutional versus what might not be constitutional or may be patently unconstitutional. Quarantine versus cordon sanitaire. Isolation with known information versus speculative isolation or quarantine. Travel recommendations versus basically some sort of lockdown that inhibits ingress or egress. These issues are profound. Let's play them out a little bit as we see some of how it works in regards to closures, assembly limitations, travel restrictions, and then quarantine and isolation. Now, a quick word before we launch into these four really key social distancing measures. First of all, some of these same observations that I will lay out here momentarily apply to other social distancing techniques like curfews and other things of that nature. Second, I'm totally aware, as you all are too, your specific jurisdiction may work differently than what we're discussing in this specific session, but we're going to give you some of the best ideas and best thinking legally so we can actually play some of this out. Now, those are where your questions come in. If you have a key difference and you want to know more about, let us know, either here today or separately. But importantly, we'll work with some general good observations and see a little bit how it's playing out nationally. So let's start with closure, shall we? If it's possible to close enterprises from a private sector perspective because they make their own choices, like at Amazon or the Ultra Music Festival or the NCAA, or private or public universities like the University of Washington before anything was mandated, they shut down. Boston shut down their St. Patrick's Day parade. Hey, good effort. That's exactly what we're looking for in so many different ways. Voluntary closures that make a nice difference. Why? Because if it's voluntary, we don't have the legal trappings of what and how things could get tough. But to be sure, mandatory closings are not just on the table, they're happening, as we know. And they're raising some really tough questions across the jurisdictions. Who actually is authorized to close what and when and for how long? And what level of government is supposed to do that? Is that a federal mandate that can come down? Do you really think the feds can close private sector businesses and states? What about what standards we're going to use for the purposes of this? You know, what is the actual basis to shut down one enterprise but leave open another? This is going to be profound and difficult sledding for sure, but no more difficult than I think in one particular area that we're seeing play out, school closures. Now, one of the most important observations that you see, and I bet a lot of you all are sitting in jurisdictions right now, like here in Arizona, where schools are officially largely closed for several weeks ahead, pursuant to governor's order through Governor Ducey. You're against the backdrop of assessing what and when and how school closures may occur, for how long, and under what circumstances. And you're thinking, well, gosh, if the feds recommend the school closure, as you might see from CDC here in a minute, certainly that may happen nationally. It doesn't work like that, as we know. This is not a light switch that you turn on and off. We talked about that a little bit before, but from a social distancing perspective, profound and difficult choices are playing out. Some of them are political. More of them are just pure legal. Let's talk those through. First of all, CDC has issued its school closure guidance. Now, this decision tree from its guidance, which is much better spelled out on its website, you can click on this later on our COVID primer to actually gain access to it, really plays out the scenario that we thought would be helpful. We've got the three issues of a potential COVID person in the building. We've got the issue of no community spread, and then we've got the issue of minimal to moderate or substantial community spread. Put the other two off on the table. We're all basically in the role of minimal to moderate or substantial community spread. Every school is having to consider that part of this decision tree. And how are they going about it? What are the circumstances in which you can actually close these schools? Honestly, From a legal perspective, with knowing we're in emergency statuses in every state, this decision does get a little bit easier as far as having the authority to do it. As we've looked at over years, actually it was back with some of the pandemic work we did years ago with CDC, we've seen there is explicit authority to close schools in all sorts of different environments, but that gets upgraded big time in relation to what and how emergencies make that difference. It's that declaration that authorizes that level of closure of an enterprise that's run by states in most cases, or local departments obviously, or from a private school perspective, regulated by states or otherwise. Do they have the capacity and legality to actually close schools for specific durations in response to COVID? Hey, the answer is going to be in so many places. Yes, you can find that authority to do it. But on what criteria? Who makes the decision? How long will that decision go? It's a tough battle, and it's not made any easier by this simple observation. If you're going to close them, when do you reopen them? When legally can you do that? I mean, you can follow CDC guidance on this, but you're going to know that COVID's spreading differently in different localities based on all the things we're trying to do from a social distancing perspective. What actually is the appropriate legal standard for reopening the schools, and how might we predict that? That will be a question we'll actually see more of in the very near future, but to be sure, it's a tough choice and a tough one for a lot of jurisdictions presently. What about assembly limitations? We've got all sorts of ways to limit assemblies in relation to what we're doing in real-time social distancing. So you've seen this. We've seen everything from all different types of religious worship to even the Democratic debate last evening moved from right here in Phoenix, Arizona to Washington, D.C. and CNN studios there with no crowd and only basically about 5 people in sight, including the 2 remaining candidates. These are profound limitations, but they do raise very significant issues of how you actually order these. And so what you're just seeing here is this prototypical order that you're seeing here from Santa Clara. It's a nice example. They did a great job of actually just drafting what and how might justify the specific order of closure for specific assemblies or limitations. One of the things I really like about this, you can click on it to just see it a little further, is to actually really closely and quickly identify what authority they're actually pointing to through the California's Health and Safety Code that actually gives them the power to do that in an emergency or otherwise. That's smart from a legal perspective if you're going to attempt to actually limit assemblies of which people have constitutional interest in. You'll want the definitive opportunity to accomplish that by naming that specific legislative or regulatory power. Now, this bombshell came out a little bit over the weekend. And I call it a bombshell because what these colleagues recommended through the Center for American Progress, led by Zeke Emanuel, was something a lot of people really weren't perceiving or talking about extensively. It got serious in relation to looking at the epi of limitations of assemblies and basically came down with certain recommendations like, if we're going to get serious about tamping down on COVID, ban all gatherings of greater than 50 people. For seniors, ban them for more than 10 people because they're particularly at risk. Places of worship, cancel services if it's greater than 25 people showing up. Concerts, conferences, sporting events, forget about it. Employers should require employees to work remotely. They went on to even suggest anywhere where you have community spread, which is starting to look like almost everywhere in the United States, at least from a state sort of overview. Close the schools, colleges, gyms, bars, movie theaters, libraries, community centers, limit restaurant capacity. Gosh, what can't be closed under those recommendations is amazing, especially when the day after that CDC issues this guidance you're seeing on screen and probably heard about reported nationally through media, basically recommending for the next 8 weeks, any organizer of any type cancel or postpone in-person events of greater than 50 people. So they're basically taking that recommendation we just saw through the Center for American Progress, and CDC has made it quite clear now. We highly recommend this. Can it mandate it? No. Can it highly recommend it and have states follow in line? Yes. And to be sure, some states and localities already are. I saw Kansas City just last evening said, we're going to do that. We're going to actually put those limitations in place. As you do that, you do trip on these sorts of issues. Again, what authority? Can you find it? Can you spell it out? The emergency authority may have general opportunities for that, in other words, generalized statements of it, but you work better against the backdrop of having specified authority. In most cases, you're going to see it in your state code or your emergency declarations for sure. Who's going to make that decision? Obviously, your top health officials, your governor, or others. If it's a statewide sort of issue, at a local level, your mayor, your county council, that's going to be, obviously a level of which you would be pursuing that type of critical decision. What specific setting or capacity? What are you going to close or leave open? What assemblies are you going to allow to occur and not? For how long? Again, 8 weeks, what CDC recommends for that size of 50 persons or more. But let's also be conscientious of the First Amendment rights at stake. Look, people have rights to free speech. They've got freedom of religion. They've got reasonable limitations you can set on that, but the freedom to assemble is legit. It's fundamental. It's something we count on as Americans, and it's central to so much of what and how we perceive our rights in these events. Can you curtail that freedom to assemble constitutionally against the backdrop of COVID? Oh, yeah. Yes, it can be done. The Supreme Court and others have recognized in multiple different cases there are definitive limits to rights to assemble, and this is one of them, where your right to assemble produces a greater risk to the community. We have legitimate justification to temporarily infringe on that specific freedom to assemble and other rights that may be implicated along the way, including religious interests and or free speech. This can't be without significant justification, but right now against the backdrop of COVID spread, we very well have it. What are we looking at from a travel restriction perspective? Oh, this is going to get interesting and dicey fast, so watch out. First of all, foreign travel restrictions. President Trump's used his existing power to actually create a bunch of different travel restrictions for persons who are non-Americans coming into the country. So the last one you saw, of course, was on March 11th, President Trump instituting a 30-day comprehensive travel ban for non-Americans arriving back from the EU, and now he includes within that the UK and Ireland. Now, these are serious, and you saw those go into place over the weekend, clogging up airports and security lines extensively. Does he have the authority to actually do that? Yeah, he does. There's specific enough authority because of the Fed's solely control for border closures and border-related initiatives against the threat of something in the nature of COVID, even if this particular intervention may not prove efficacious fully, as WHO suggests all the time in relation to these types of border restrictions. The capacity for the president to institute that, it's there. Now, with that said, let's take that to another level. And this is where things get fun and fast. Now, you've seen Dr. Fauci make several comments, and actually a week or so ago, he made it quite clear that he actually saw it as quite possible that a regional lockdown of Americans in their own domestic settings might be something we have to consider. And yesterday on multiple talk shows, as I mentioned, he said everything's on the table. Let's look at it all. Is this actually something that's possible in the United States to consider a lockdown of major metropolitan or even smaller communities? Well, to be sure, there are some serious constitutional implications of that. First of all, there are substantive due process, equal protection rights that would be completely negated, and we have to be conscientious that those do not, again, go away. They may be rebalanced, but they're on the table for sure as far as definitive rights. State border closures, gosh, highly limited, even in emergencies. The feds would have to agree to that, and mind you, it is hard right now to predict what the White House may suggest as necessary to that end, but you don't get to close your borders as a state or a locality. States could shut that down. Lockdowns from a public health perspective raise significant issues because they actually might place persons at greater risk. Locking down a community, literally restricting their movement in or out of that community, does present real significant problems in relation to actual public health interventions for those persons. There are always, to lockdowns, less restrictive alternatives. That's critical because constitutionally, that's what the Supreme Court's going to be looking for against the backdrop of compelling governmental interests comprised and balanced with fundamental rights. Is there a less restrictive alternative? There is. We have and are using them. When you add up closures of public places and schools, private entity decisions to close, the screening of persons that we can do, the sort of strong messaging that's out there to avoid travel, and when you add up that with quarantine or isolation measures, all of which are constitutional, you basically create a virtual lockdown without having to order a lockdown. But the most important thing I can suggest in regards to that observation is if you were to walk into court against a backdrop of being challenged on some of these initiatives and basically say, well, we're here, but honestly, what we've done is a virtual lockdown. I think you're going to lose on that big time. We've not done that. We've created a public health and safety zone. And these measures from a social distancing perspective are all we've got to combat COVID right now in real time to limit its spread. We have the authority to create that zone, so long as we don't overly infringe on individual rights, like the right to ingress and egress as guaranteed through rights to travel norms to the Supreme Court. That's what we're up to in regards to public health justification. We're creating a zone through which people's health is maintained to the fullest degree possible. That could be a winner, but this lockdown mentality in regards to U.S. intervention could be serious and significant. What about quarantine and isolation? Let's walk through this quickly, promising as I have to make sure we get to tons of your questions. So, quarantine and isolation present some of the most interesting observations we know. We all know what they mean, I think by now, obviously, in relation to the difference from a public health perspective. But to be sure, this one slide illustrates it pretty neatly. Quarantine, they separate people that were actually exposed to contagious disease from those who haven't been. So you were in a room with somebody with COVID, you might have been exposed. Let's put you aside just for a while to watch you carefully. Isolation, you've got it. We know you do. We're going to have to isolate you in a separate place to make sure those who are not ill, the healthy individuals, or even those who are exposed, don't actually get infected too. Now, to be sure, it's questions of where and when and how we implement quarantine that makes a huge difference. Where are we doing quarantine isolation? Well, literally everywhere in the United States you can imagine, hospitals, nursing facilities, shelters, even in prisons. But the dominant place we're obviously using it for good reason constitutionally is at home, shelter at home. Quarantine and isolation measures that place people within their own home setting are the dominant feature of what we're seeing nationally and will continue to be, I dare say, with very strong legal support for why. Now, what authority do we have to do this? Well, you know, federal government through CDC has created its own new regulations pursuant to the Public Health Service Act to actually conduct quarantine isolation, and it's done so. States, tribals, and locals have that specific authority through their police powers. They are extensive, even if diverted down to states through home rule, to actually investigate, assess, quarantine, and isolate in emergencies. Let's break those down a little bit further. For example, with a CDC authority. They've been doing quarantine for years, as you know. We've got 20 quarantine stations across U.S. airports in the United States, and CDC uses that power there where necessary on almost a single case-by-case basis. We're not playing with case-by-cases now. CDC's definitely upgraded its significant intervention of its federal quarantine powers with multiple quarantines instituted against hundreds of Americans coming back on those repatriation flights, as well as through the cruise ship that was infected off the coast of Japan. We've seen these played out largely successfully, but to be sure, they've raised some litigation at the local level. The not-in-my-backyard type of approach you saw a little bit emanating in Costa Mesa, California, and then, of course, litigation, all of which has been dismissed, but at least raised in San Antonio for the purposes of suggesting, hey, you let somebody off that military base, CDC, who might have still been infected with COVID, so we're not going to allow any of them to return to the city of San Antonio. The federal judge threw that out, but more litigation is likely to come against these types of backdrop of that federal, state, local balance. We're watching it closely. We're going to continue to give you updates on those fronts. Let's play it out a little bit at the state level, though. And let's do so by acknowledging the following. First of all, again, as a reminder, we're totally aware and know in your jurisdiction, wherever you may be, your quarantine and isolation laws could, on the books, reflect some different principles. What I'm going to sort of convey here is the type of principles that if you can observe and follow systematically in this COVID emergency event, I think you'll escape potential concerns, constitutionally and otherwise. Let's look at them just briefly. So you got option A. This is what and how 95% of quarantine and or even self-isolation cases are being processed and dealt with in the United States at the state and local level. We are going to issue you a written directive through the Public Health Authority, and we're going to ask you to quarantine voluntarily on your own, at home, or other setting that's a safe zone for others. We're going to do that without having to go through courts. We're going to do that in a way that's fast and efficient and make sure that you get the process you need, but that's the typical option, and we're using that extensively. Sometimes that may not be enough. Sometimes you have to go to option B, and that's the quarantine or isolation with judicial notice. Or it could be that maybe you've temporarily quarantined or isolated persons in a specific setting, but shift to option B to make sure that you can meet due process norms. When you get to option B, we're talking about petitioning courts in real time that are capable more and more now of absorbing these type of cases, many of them getting up to speed systematically on this. I know here in Arizona we have, and I've seen a lot of additional state-based preps for this, to basically receive these specific petitions to actually assess whether quarantine or isolation is justified under specific circumstances. In emergencies, more times than not, you're going to see the authority to do this on an individual case or groups, like an entire group of persons that may have been exposed to COVID in a particular setting. A quarantine order or isolation order, if you know they're infected, may be forthcoming with a group mentality, but you better spell out some of the stuff you're seeing on screen here. What's the identity? What premises are we talking about? What's the date and time it commences? What type of disease we're dealing with? COVID, obviously. Contagious, yes. Deadly, yes. Statement of compliance with conditions and principles, you'll see in a moment, and the basis on which those interventions are justified. There'll be some notice. There'll be a hearing. That may be done through video or through audio, but it is legit under due process. And there'll be orders that can be set by the court if by clear and convincing evidence it's shown that quarantine or isolation is reasonably necessary to prevent or limit the transmission of COVID. It's going to stick, I dare say, in regards to what you had at least a great leg to stand on to implement those specific orders. Again, option B, I don't see it for most cases, and you all know some jurisdictions are flat out not abandoning quarantine and isolation, but they're just basically saying, we know it's so extensive within the community as testing starts to become more prevalent, we're simply asking for people to engage in a high level of social distancing and moving aside from quarantine or isolation orders through courts and otherwise. If you're doing quarantine and isolation well and constitutionally, you're providing to whatever degree you can, if it's off-site, a safe, hygienic premise. You're allowing competent medical care, in fact, providing it. You're giving people a means of communication. They have First Amendment issues here, and give it to them. And they have adequate food, clothing, and medication. You don't push people aside without those basic necessities when you're housing them for a quarantine or isolation initiative. But there's a few other best practices. First of all, just remember that less restrictive principle. That means when you only go so far with it when it's necessary to prevent the spread of contagious disease. When it's not or that threat diminishes, they're out of quarantine or isolation. Isolated individuals should always be confined or kept separate from quarantine individuals. Don't mix them. That's not good. It actually places more persons at risk, as we know. The health status, you don't just check once. You check constantly to make sure that that person is still a viable candidate for the purposes of quarantine isolation, particularly when you've had to go through court orders or you're housing them on your own state or local facilities. Let's do the best we can to observe cultural and religious beliefs. I think that's not just smart. It's actually constitutionally a viable moment. But again, it's going to be to the extent we can pull that off. And to be sure, quarantine or isolation should be immediately terminated when any individual poses no more substantial risk of transmitting disease to others. It ends at that moment, and it does not continue on for more than it has to. These enforcement measures are ones we're familiar with, but let's just be honest how they're playing out. First of all, on the left side of your screen, the voluntary measures. Use them to the full degree possible. This is what we're after. This is what's going on nationally. Voluntary measures, please participate with quarantine and or self-isolation is working in a lot of cases. Sometimes you may need to throw a carrot out there. We're going to allow you to quarantine at home, but you're going to have to do that and check in with us as local authorities, and we're going to actually be really stepping in to make sure that you're observing that. That's smart too, and it's lawful. It's actually a great way to assure compliance without having to go to the heavier route, because should somebody breach quarantine or isolation, at least to the degree to which we can monitor for that, that's going to be increasingly harder as quarantine and isolated cases start to mount across the United States. But if you know of known breaches we've seen examples of nationally, it's time to go back to court, and we can get orders there that actually would either find them in contempt or potentially go the full route of CDC would have the capacity to do, pursuant to its quarantine isolation powers, rather significant penalties. If you want to walk off that military base, if you want to evade that quarantine center at a state level, if you want to leave your house and actually engage in activities that do present others at risk, it can get tough fast. But to be sure, this is something most public health authorities don't want to have to go to. Legally, can you do it? Yeah, if your state code spells it out. So two other quick observations, then we're right on to your questions. First of all, costs and reimbursements. Who's paying for all this? I mean, honestly, how are we going to pay for the tens of millions of dollars already assembled by states and or local governments. How are we going to accomplish the public health delivery of these services against the backdrop of hemorrhaging departments that are struggling anyway with, sort of backed up budgets that have been cut over years? Well, the good news is we have the potential authorization now for, first of all, some real state infusion of funds. We're seeing a lot of states appropriate through legislature and governor-related emergencies real funds to make some of this happen. That's good news. There's the potential to use federal funds through the Stafford Act for some direct reimbursements. Let's not get too excited there momentarily, because the reason is we may see that fund drain faster than we can possibly get to it, but it does have the capacity to help pay for some of those medical countermeasures. But you know who I'm really worried about? It's the state and local public health officers trying to pay for these things, there's no question. What about affected individuals? I mean, they have a legitimate concern about how they're supposed to actually absorb these quarantine or isolation measures against the backdrop of having to work for meeting all of their specific needs, or their kids are at home and school, and it's just sometimes disastrous. Congress is looking to help on that specific front. House Resolution 6201, what's known as the Families First Coronavirus Response Act, introduced by Nancy Pelosi, I believe passed the House successfully, probably on its way to the Senate, may get to the President soon. It really does place some very good protections. Will there be enough in place for the sort of paid sick and safe time measures? We hope the appropriations will match that, but help is on the way for that, and even just basic access to some of the core things that you might expect in these specific environments. We're working nationally to accomplish that. We need to see it in place sooner than later. Even CMS is trying to, really provide the type of guidance, allowing, for example, a very clear recommendation. In fact, an order coming down from CMS making it clear quarantine isolation procedures outside the home definitely can be considered essential health benefits. In other words, insurance companies can pay for that pursuant to those plans. State and local paid sick and safe time protections in a lot of jurisdictions have kicked in. Some employers, as you know, have been very gracious about extending those through other means. That's a great civic effort. And to be sure, sometimes the provision of care can be provided without any direct costs, like in the testing or other arenas supporting quarantine or isolation. We're working on those initiatives federally. At the state and local level, they're starting to fall into place too. Will there be enough to make sure every American's met in regards to their needs? Probably not, to be honest, but quarantine isolation still remain really key to this effort. There are privacy implications involved. We'll be brief on this because we've got questions. Touch base with our colleague like Denise Chrysler within our Mid-States office for some of the best information. I've watched very carefully this week for OCR, the Office for Civil Rights, to put some additional waivers in place now with the National Emergency Act against the backdrop of the HIPAA privacy rule. There's tons more resources available through these specific places on our network website, and to be sure, I hope that brief overview gave you a lot to think about and work through. So without further ado, let's take your questions, comments. Email me at that address if you'd like after the webinar. You're more than welcome to. We'll do our best to address those. But Kayleen, let's jump right into Q&A for now. We'll address every question we can.
Thank you, James, for this important and timely information. Here's our first question. Can a city that wants to prohibit, for example, water shutoffs during the crisis rely on its emergency powers, even if water shutoffs fall within the authority of another public agency, i.e. water district? Which jurisdictional law would control in such a situation?
Oh, great question, Caitlin. A good one to start with because I didn't even get to address it at all. But, yeah, we're seeing that play out in specific jurisdictions. I've seen examples of it, protecting against the sort of pulling aside of water or other types of utilities in this emergency environment. In fact, several states' emergency orders pursuing to declaration of emergency spell that out. Do not withdraw these specific utilities for fairness and other specific reasons. But the authority to do that is so state-specific that you're going to want to actually touch base with your legal counsel as far as where to go for that, or send us an email and ask us further what particular jurisdiction will attempt to identify that for you. It's legit. It can be done. It's an emergency effort that, without doubt, under most of these states' emergency declarations, I think we could craft a way to see that happen. It's a great question to start with. Basic needs in a quarantine or isolation or social distancing setting really need to be provided, and water's at the most basic of them for sure. Kayleen, go ahead.
We're reviewing the list of what statutes, rules should be waived in the disaster, like allowing healthcare licensees to practice with inactive licenses. Are you aware of a comprehensive list of types of statutes which should be considered for waiver?
Interesting. Yes, I think so. I mean, I could list them off in so many different ways, but I think what we'll find, first of all, is that there are some definitive lists of those things that are most apt for waiver. And yeah, licensure-related provisions, liability type of concerns, definitely apt at the top of that list for waiver purposes. So, for example, with waiver of licensure, we're not talking about waiving license completely. We're talking about waiving the potential for having to go through separate, independent, red tape type licensure standards. We're going to give you reciprocity for the duration of the emergency for a lot of practitioners with either, inactive licenses or maybe coming from out of state. It's entirely possible. A lot of states have implemented that exact measure. But as far as a good list of what those other waiver possibilities are, yeah, let's circle back on that. And I dare say we'll include something of that nature in our next version of the COVID legal primer. So great question. Thank you.
What are the limits of the waiver of the HIPAA privacy rule implemented by the President? Does it apply to all persons suspected of COVID-19? Or how exactly will we be able to determine when waiver of HIPAA is appropriate?
Ooh, interesting. Now, that may just be one of those hot news items that's come about in relation to this specific webinar at this specific time. I've not seen the President expressly issue a HIPAA privacy waiver. In fact, though he made a declaration of emergency on Friday, that would be a decision that actually comes through HHS pursuant to its authority, now coupled with the Stafford Act or National Emergency Act declaration pursuant to the public health emergency. But if that has happened, at least we'll say, and we'll check on that for sure. I'm sure Denise Kreisler, our great colleague, is looked into that already. If it's happened, it's applying to anybody that might be, at risk or potentially infected with COVID or exposed to COVID. It's not something that you would see applied to just specific persons in specific settings. But to be sure, there are, definitive ways that certain waivers of the HIPAA privacy rule could facilitate emergency and other response efforts. We will follow up on that and check to see what our status is presently. Caitlin, go ahead.
Can an employer require that employees disclose all travel? Then, if disclosed, require isolation?
Well, that's interesting. Now, if the employer's private, that is, basically a private sector employer, they can certainly inquire to that effect. I think that's actually interesting from a general observation. If the employer is concerned about the workplace setting and its potential to be contaminated with COVID, and as you know, it can be left on surfaces and other things that do create real risks, I think that is a legit issue for a private employer. And the reason I emphasize private there is if it's a public employer, aka government, you get into some of the constitutional issues that might relate to certain privacy or other issues. But honestly, against this backdrop of multiple emergencies at every level of government, I think we're in a pretty good position to say, yes, do inquire further about travel histories and set reasonable guidance and regulations for what employees should observe in regards to limiting the risk to others. That's not just smart. That's not just good practice. That's going to be something that from a legal perspective, I don't think would trip too many concerns about privacy or disability-related protections or otherwise. We are out battling a very serious menace here. That sort of measure might be quite agreeable. Go ahead, Caitlin.
At our state meetings, I have heard some law enforcement express frustration that those who violate an isolation or quarantine order may only be given a misdemeanor and not a felony. They don't feel as though there's any teeth to forcing someone into isolation or quarantine if they can't arrest.
Wow, that's a very interesting observation. Like where law enforcement's basically saying, we want to throw the book at them almost from that background or perspective. Listen, this is one of those things that gets very dicey from a public health perspective. We're loath to use those criminal penalties. We're loath because the moment you lose that trust with your community in regards to implementing social distancing, the moment government or American citizens feel like there's a serious heavy hand weighing over them in regards to these specific measures, they may take them very seriously. But there are consequences as well, like avoiding all potential testing or all potential authorities trying to implement these measures. This is a very delicate balance from a public health practice perspective. So my best suggestion is to recognize what officially may be on the table, and it includes as follows, specific persons who are proven recalcitrants that may prove to be problematic for evading quarantine or isolation. those are the types of persons of which additional measures may have to be necessary, including contempt or other types of issues that courts can play out. But I would not be out publicizing to a greater degree this type of felony type of interventions that could be implemented. Even if you thought that might be a greater deterrent, it can go the wrong direction, leaving people reticent to actually participate in any public health objectives around testing or otherwise for COVID. So it's a very careful policy balance, and I'd say watch out on that front for sure. So, Kayleen, go ahead.
Any advice for educators, school nurses regarding notification of positive cases? Specifically, if a parent of a kindergartner informs a principal that they tested positive, what is the school's responsibility to protect that parent's privacy versus notifying?
Oh, I know. Gosh. First of all, turn that over to local public health authorities and let them know about that. I think they're very well positioned to actually facilitate that specific exchange. They're completely pressed. We're totally aware of this, but in regards to what and how they can do the contact tracing and official notification, they do it well. They know how to accomplish that. I would bring in the public health authority at the local level to make some of that happen. Because what you're going to see, you've already seen it, honestly, you're going to see parents make explicit claims to need very private information about what kid or what parent under what circumstance had COVID in that community. There is very little justification from a privacy perspective to let that information out the door. What those other kids and parents are entitled to be made aware of is that you may have been exposed to COVID in this school setting, but how that occurred is, from a privacy perspective, very sensitive, and even under the HIPAA privacy rule, even if it's waived ever so slightly, that's not about allowing publicized information there. Best recommendation, again, from just guidance, not specific legal advice, get your local public health official involved immediately. Let them handle that contact side of it. I think that'll go very well. Kayleen, go ahead.
While encouraging compliance with isolation quarantine requests, is there an appropriate method of conveying the potential risk of public vigilantism without such a message being interpreted as a thinly veiled threat to comply?
Wow, I know. Gosh, such a great question. Sadly, we're seeing some of that arise nationally, and we have a multitude of examples of it in prior epidemic outbreaks with Ebola and other specific fronts. It's a really good observation, how you actually create that communication. I'd like to look more carefully, and I'd be very happy if the requester who issued that question sent us a separate email to look a little more carefully about some of the best messaging that we're seeing. So, for example, we're looking all across the country at some of what and how local officials are responding, and I've seen great stuff from everywhere from Houston to San Francisco to New York City. But I'd like to see whether there's a really good model approach for how to make that messaging effective without it potentially being problematic for the recipient. So good one. And to be sure, email us separately on that. Love to see more and have an opportunity to address that directly with a very good example. Kayleen, go ahead.
What impact does Friday's declaration of emergency have on tribes?
Nice one. So listen, tribes are sovereigns like states, and they, to the degree to which they have sovereign authority, possess very similar rights or very similar powers to what states do in the use of those sovereign authorities. We see multiple tribal governments, and there are dozens more, I'm sure, that have made declarations, but we tracked them on that one slide you all saw earlier. So those sovereigns, from regards to that particular perspective, could be still and are directly affected by the national emergency because those sovereigns, they have a different special relationship with the federal government. I think you will see certain provisions within some of the national tribal enterprises that are overseeing, like the Indian Health Board and others, some tribal initiatives. You're going to see special guidance and facilitation and assistance provided under those circumstances. That relationship's unique enough that while tribal entities retain their sovereignty and the capacity to respond within their own populations like states, their relationship with the federal government, I think, may lead to some infusion of potential assistance that could make a nice difference. But that's one as well we want to craft out and see in real time through some of our prominent tribal authorities at the national level.
HUD and some public health agencies are delaying or suspending inspections into health hazards in the home during COVID-19. Is there a way to protect people who are being asked to shelter in place in homes that threaten health, i.e. have mold, leaks, lead paint, etc.?
That is a neat observation. So we've got some great colleagues in our network that actually look into some of those arenas, and I want to tap into some of their perspective in the Eastern region at the University of Maryland with our great colleague Kathy Hogue. But to be sure, I think, yes, there are ways to accomplish that to the degree to which you have the capacity to do it. That's the only issue at this juncture. I think so much of what you're seeing at the state and local level is such a great attention to just the pure COVID social distancing response efforts right now. Some of these peripheral issues are equally serious and problematic, and they're ones for which, for example, like on mental health and child-related care and other fronts, can be the more profound issue for populations than the threat to COVID in and of itself. But how to actually think through the best ways to still accomplish those sort of assessments or investigations, even during the throes of what could be a multi-week-long social distancing strategy, totally worth looking into, and to be sure, tap into what we can do and look at through our Eastern Region office as well. Caitlin, go ahead.
Can a local government require firefighters and police officers to report to work during a declared emergency, notwithstanding safe and sick leave to the contrary?
Oh, I know. Gosh, right. That is such a good observation. So you have your paid sick and safe time provisions in place, and yet simultaneously you really do need those EMS and fire department and other law enforcement officials to report against the backdrop of potentially having to place themselves at some risk in that regard. These are public servants. They act pursuant to such great and heroic efforts in these emergency events, like all of our healthcare workers and all of our federal, state, local public health practitioners for sure. The capacity to have to report to work against the backdrop of somewhat may be potential threats to their health is a very difficult situation that some localities are having to work through. We've actually heard from some fire departments through the network across the country to that same effect. These are dicey. These are tough issues for sure. From an employment perspective, as a public servant pursuant to what is needed in a real-time emergency, yeah, I think you could see reports to work as necessary at this juncture just based on what that particular relationship may be. But again, we're conscientious of the paid sick and safe time provisions, what and how employees may be seeking to use those effectively for the purposes of preventing potential spread. It's a very tough and dicey balance. I hope that at least gives some observation to what and how far you may be able to go with it. But ask us further and we'll be happy to look into that too. Kayleen, go ahead.
We were told in the past that Stafford Act funds could not be used for outbreaks. Has that changed? Should we be encouraging local and tribal governments to seek these funds?
Well, I think the thing that's changed is very clearly pursuant to the dual national emergencies that we're now in, the National Emergency Act and the Stafford Act. We've invoked everything that the federal government, absent declaring this a national security threat, can actually utilize to that advantage. I think President Trump's made it quite clear he's tapping into that federal disaster relief fund for FEMA to use specifically for purposes of intervening and assisting with state efforts. Those are going to be purposeful, and you're going to see that too. But I saw distinct language, or at least heard from distinct sources, that to the degree to which there are opportunities for reimbursement of direct medical countermeasures being implemented by states, that will be on the table. Now, I'm not going to say the fund will be there with resources already to actually conduct that reimbursement, but I would absolutely be watching for this and watch for Congress to replenish that fund in the very near future too. It's going to be drained fast. But to be sure, Congress now has the ability with the Stafford Act declaration to quickly also add to it consistent with presidential oversight and directive. So timing-wise, Kayleen, we may have time for one more question. Go for it.
Is anyone watching closely what is going on in detention centers for undocumented immigrants, and what is happening in the 10 cities just south of the border?
Oh, I know. We've got now south of the border, I can't really speak to, and I apologize for that because we've just not been able to connect as much to the network with some of our colleagues on the other side of the border, here in Arizona and otherwise. But on this side of the border, yeah, there is attention to that. We've been looking at some of these issues specifically through, various different concerns about the sort of implementation of the public charge rule. Our colleagues in the Western region have done a great webinar on that with some additional insights there. It's separately up on our webpage. We may even have some additional materials coming on that soon. It's a profound series of issues, truly. And what and how we're actually going to work through those for that specific type of population and so many other vulnerable populations that we cannot leave by the wayside in relation to COVID response efforts. To do so would be not only unethical and just patently just premised on everything that you could imagine to be wrong in regards to effective response, but these are the types of persons that we're really looking for the purposes of making sure that at least fundamental basic protections to protect their health are in place, and government's the only resource we're going to be able to accomplish that through. So without being too long-winded on this, check back in with us or check out what we've also got on the public charge rule and other issues at the network website, but let us know separately, as we've heard from multiple different national requests on this, about the repercussions and some of the best guidance that's out there.
So thank you, James, for presenting today. I know that we here learned a lot, and I hope that all of our attendees did as well. So just a few final notes to everyone who attended our webinar today. If you submitted a question that did not get addressed during the Q&A session, don't worry. We'll be reaching out to you to ensure your question gets answered. Also, all attendees will be receiving an email from the network with the video playback of this webinar, as well as a link to our brief webinar survey. The survey takes just 1 minute to fill out and provides us with some really great insights, especially in regards to what topics you would be interested in for future webinars. If you enjoyed this webinar, be sure to check out our next webinar occurring this Thursday on public health impacts of legalized sports betting. And finally, registration has opened for the 2020 Public Health Law Conference, where attendees will learn legal and policy tools to address fundamental drivers of inequity, promote health and well-being, and save lives. You don't want to miss it. So that concludes today's webinar. Thank you all for attending, and have a great rest of your day.